An exclusion clause is a term in a contract that seeks to restrict the rights of the parties to the contract. Traditionally, the district courts have sought to limit the operation of exclusion clauses. In addition to numerous common law rules limiting their operation, in England and Wales Consumer Contracts Regulations 1999. The Unfair Contract Terms Act 1977 applies to all contracts, but the Unfair Terms and Consumer Contracts Regulations 1999, unlike the common law rules, do differentiate between contracts between businesses and contracts between business and consumer, so the law seems to explicitly recognize the greater possibility of exploitation of the consumer by businesses. Types of exclusion clause. True exclusion clause. The clause recognizes a potential breach of contract, and then excuses liability for the breach. Alternatively, the clause is constructed in such a way it only includes reasonable care to perform duties on one of the parties. Limitation clause. The clause places a limit on the amount that can be claimed for a breach of contract, regardless of the actual loss. Time limitation. The clause states that an action for a claim must be commenced within a certain period of time or the cause of action becomes extinguished. Term must be incorporated. The courts have traditionally held that exclusion clauses only operate if they are actually part of the contract. There seem to be three methods of incorporation: incorporation by signature, according to Lestrange v. Grocob, if the clause is written on a document which has been signed by all parties, then it is part of the contract. If a document has not been signed, any exception clause which it contains will only be incorporated if the party relying on the clause can show that he took reasonable steps to bring it to the attention of the other party before the contract was made. In somewhat of a contradiction, that is not to say that the profferent actually has to show that the other person read the clause or understood it. It is not even necessary to show that the attention of that particular person was actually drawn to it. It is somewhat like the reasonable man test in tort. The party trying to rely on the clause needs to take reasonable steps to bring it to the attention of the reasonable person. Incorporation by notice. The general rule, as provided in Parker v. S.E. Railway, is that an exclusion clause will have been incorporated into the contract if the person relying on it took reasonable steps to draw it to the other party's attention. Thornton v. Shoe Lane Parking seems to indicate that the wider the clause, the more the party relying on it will have had to have done to bring it to the other party's attention. The notice must be given before formation of the contract as illustrated in Ollie v. Marlborough. Incorporation by previous course of dealings. According to McCutcheon v. David McBrain Limited, terms may be incorporated into a contract if course of dealings between the parties were regular and consistent. What this means usually depends on the facts. However, the courts have indicated that equality of bargaining power between the parties may be taken into account. Judicial control of exclusion clauses. Strict literal interpretation equals, for an exclusion clause to operate, it must cover the breach. If there is, then the type of liability arising is also important. Generally, there are two varieties of liability: strict liability and liability for negligence. The courts have a tendency of requiring the party relying on the clause to have drafted it properly so that it exempts them from the liability arising, and if any ambiguity is present, the courts usually interpret it strictly against the party relying on the clause. As espoused in Darlington Future Limited v. Delcon Australia Proprietary Limited, the meaning of an exclusion clause is construed in its ordinary and natural meaning in the context. Although we construe the meaning much like any other ordinary clause in the contract, we need to examine the clause in light of the contract as a whole. The Judge in INB Custom Brokers Company Limited v United Dominions Trust Limited refused to allow an exemption clause, of which did cover the nature of the implied term, on the grounds that it did not make specific and explicit reference to the term. Contra profferentum equals, if, after attempting to construe an exclusion clause in accord with its ordinary and natural meaning of the words, there is still ambiguity, then the contra profferentum rule applies. Essentially this means that the clause will be construed against the person who imposed its inclusion. That is to say, contra the profferens. In terms of negligence, the courts have taken the approach that it is unlikely that someone would enter into a contract that allows the other party to evade fault-based liability, As a result, if a party wishes exempt his liability for negligence, he must make sure that the other parties understand that. The decision in Canada SS Lines Limited v. The King held that, if the exclusion clauses mention negligence explicitly, then liability for negligence is excluded. If negligence is not mentioned, then liability for negligence is excluded only if the words used in the exclusion clause are wide enough to exclude liability for negligence. If there is any ambiguity, then the contra profferentum rule applies. If a claim on another basis can be made other than that of negligence, then it covers that basis instead. In Australia, the Four Corners rule has been adopted in preference over the idea of a fundamental breach. The court will presume that parties to a contract will not exclude liability for losses arising from acts not authorized under the contract. However, if acts of negligence occurred during authorized acts, then the exclusion clauses shall still apply. See also, if the contract is for the carriage of goods, if the path is deviated from what was agreed, any exclusion clauses no longer apply. In Australia, exclusion clauses have been recognised as valid by the High Court. They do not apply in cases of deliberate breach. Statutory control, even if terms are incorporated into the contract and so would be effective, there are various statutory controls over the types of terms that may have legal effect. The Unfair Contract Terms Act 1977 renders many exemption clauses ineffective. The Unfair Terms in Consumer Contracts Regulations 1999 provide further protection for consumers. References: 1934, 2 kilobytes 394, 4 CPD 416, 1971, 2 WLR 585, 1949, 1 Aulia 127, 1964, 1 WLR 125, 161 CLR 500, 1988, 1 All ER 847. The term in question was the implied term as to fitness to purpose pursuant to the Sale of Goods Act 1979 S14, 3. Darlington Futures v. Delco Os HCA, 1952, AC 192, The Council of the City of Sydney v. West 114 CLR 481, Davies v. Pierce Parking Station Proprietary Limited, 1954, HCA 44. Clear words are necessary to exclude liability for negligence. Thomas National Transport v. Mayen Barker, 1966, HCA, see Thomas National Transport Proprietary Limited v. Mayen Baker Proprietary Limited, 1966, HCA 46. 115 CLR 353.